All right, well, good evening, everyone. My name is Tony Van Duzer. I'm a professor at the University of Ottawa at the Faculty of Law. And on behalf of the faculty and our academic partner, the World Trade Institute, and our very generous sponsor, the Center for International Governance Innovation, CIGI, I'd like to welcome you to our panel tonight. The subject of the panel, as you know, is Canadian foreign investment law and policy in a global context. Are we getting it right? But before I turn matters over to our moderator, Una Fitzgerald, who, as some of you know, is the director of the International Law Research Program at CIGI, I did want to make a couple of comments about why it is we're having this event tonight. As some of you know, we're having at the University of Ottawa a workshop today and the next day where we have brought together experts in international investment from various disciplines, including law, economics, management, and political science, to talk about investment issues. And the goal of this workshop, there are essentially two goals of the workshop. The first is to get these people, assembled experts, to talk about a variety of subjects related to investment from their distinctive disciplinary points of view. And then through the comments and the discussion from the diverse group in the room, to try to see to what extent insights from a variety of disciplinary contexts and using a variety of different sort of approaches to this sort of global issue of international investment can actually help us to better understand how it is that countries can use laws, treaties, institutions, and other strategies to improve their ability to attract foreign direct investment and to manage its effects, both to mitigate the risks and to maximize the likelihood that it will receive benefits. So those are papers that are being presented and commented on, and eventually those will be published in a book, we hope, around the end of this year. The second goal of the workshop is actually to talk a bit about a course that the World Trade Institute and the University of Ottawa Faculty of Law are planning to launch in 2016, which will take the sort of interdisciplinary learning that we hope will result from the workshop and use that as the foundation for the course material that we will deliver globally online beginning, as I say, in early 2016. So those are our two main goals. So in that context, we thought it would be useful to have a public session, both to advertise what we were doing a little bit, but also, and perhaps more importantly, to look at these issues in a Canadian context. With a view to informing Canadian investment policy, looking at some of the challenges, looking at some of the options, and to do that by assembling a panel with a variety of points of view. And so I think we can anticipate from that standpoint a lively discussion from the panel that we've assembled. So with that general introduction, I'll just introduce briefly the members of the panel. Starting on my extreme left, your right, we have John Weeks, who is a longtime Canadian public servant and former Canadian ambassador to the WTO, and currently a senior business and policy advisor to the firm of Bennett Jones on issues related to business, government relations, and international trade. Beside him is David Schneiderman, who is a well-known expert in international investment law and teaches at the University of Toronto. Beside him is Howard Mann, who is the senior advisor on international law for the International Institute for Sustainable Development, and Howard has years and years of experience working in the investment area and advising governments, particularly developing country governments, on investment policy. And then finally we have from the University of Calgary, Eugene Beaulieu, who is an economist and also teaches in the Faculty of Management there. So we have, I think, a very good panel, and with that I think I will turn it over to Una.
Thanks very much, Tony. Good evening, ladies and gentlemen. It's really a pleasure to be here, and the International Law Research Program of the Center for International Governance Innovation is very happy to be able to sponsor this event in collaboration with University of Ottawa and the World Trade Institute. So the theme is Canadian investment law and policy in the global context. Are we getting it right? And this is meant to be a complementary event to that workshop that was described by Tony a few minutes ago. Let me just tell you a little bit about the Center for International Governance Innovation and the International Law Program in particular. There is a little brochure outside you can get if you want more information, and you can certainly go visit our website if you're interested. We've been in operation now for 1 year, and our areas of research are international economic law, international environmental law, and international intellectual property law and innovation. So obviously the topic of investment, inward investment and outward policy on investment is very critical to our work. The research program is funded by co-funding from private donation by Jim Balsillie and also from the province of Ontario. And since we started our operations, we've already developed a number of research projects in these 3 areas of research. And the way we like to work is in collaboration with public, private, academic, and non-governmental international law experts and stakeholders from Canada, from Ontario, and from around the world. So we're building many networks as we go forward. So let me just explain the format of this panel. We have 2 economists, esteemed economists, with a great deal of practical experience as well as academic experience. We also have 2 very experienced international lawyers, academics and practitioners as well. So I think we can have a lively debate about whether law policy leads and how it will change going forward. So as moderator, my task is really just to ask a few questions about different aspects of Canada's policy on inward and outward investment. And I hope that we will be able to have a good exchange among the panelists, and then there'll be time also for you to engage and pose questions. This is supposed to be a very interactive session. And when people start to flag, there will be refreshments outside, and we can continue the more informal discussion outside. So we have saved time on the introductions, so I think what we can do is let's just situate the panel quickly. You've already heard about the big project that Anthony Van Duzer and Stephen Gelb, who's sitting in the front row, are working on this topic. Today, what we'd like to think about is, where are we? We find ourselves at a crossroads where there are many questions being raised about international investment agreements and investor-state dispute settlement processes. Today, we'd like to explore the fundamental rationale for international trade and investment agreements. How do they create favorable circumstances? Do they create favorable circumstances? And how can we improve the negotiation and implementation of international trade and investment agreements? We'd also like to consider the evolution and development of these agreements and their impact on the global value change. And finally, we'll explore some of the criticisms, critiques, and the future prognosis for international trade and investment agreements. And so this will be quite a wide-ranging discussion. So with that, we will begin with our first question to the panelists. Developing Canadian investment law and policy requires addressing a wide range of issues, from domestic, economic, political, and constitutional considerations to international, regional, and bilateral relations and comparative advantages. So, in designing an inward investment strategy, what incentives and policy and legal frameworks tend to attract long-term investment? And has Canada got it right? Would we benefit from a more coherent national strategy, and could we do better in managing within our constitutional constraints? Should we start with Eugene?
Oh, sure. Okay, so I guess maybe to start with the last part of your question, can we do better? I think yes. So let's just start with that. Probably everyone can agree with that. In terms of, I guess, policies to attract FDI, does Canada have it right? Let me first start off by just saying that FDI is so crucially important to our economy. I would argue to every economy, but if we're going to focus on Canada, FDI is what built this country and continues to build this country. And today we talked in this panel, in this roundtable about FDI, and around the table, people recognize the benefits of FDI. And one of the benefits, or I guess the key aspect of the benefit, is it typically involves some kind of spillover, some kind of externality. And in that sense, possibly you can make an argument for government policy to encourage more of it. I guess that's kind of where you might want to come from if you're thinking about what policy should attract FDI. Because otherwise, maybe you should think that you don't really need policies to attract FDI. Before policies were used to attract FDI, maybe investors would invest here as long as we had an open environment, as long as we actually allowed it to happen. So some countries don't allow it, or they increasingly are allowing it. But the notion that there might be some kind of spillover of FDI, and how do we know that? Well, we do know that multinational firms firms that engage in FDI have higher levels of productivity, pay higher wages. There's typically knowledge spillovers and management spillovers in other sectors. And so you could make this case that maybe you want to use policy to attract it. I guess maybe I would start by saying, instead of thinking about what policies should we use to attract it, I think if you have policies right and you have a good product, then maybe you don't need as many policies. But maybe as we go through the discussion, we can talk more about policies, because I think Canada has a whole suite of policies, and it starts with our Investment Canada Act that regulates foreign direct investment. And so I think we have work to do on that. I think we have some major problems with that piece of legislation. And then the other part of it is relationships with other countries. So we spent a lot of time today talking, and probably we'll talk on this panel, about investment agreements or trade agreements or investment components of larger international agreements. So I'll just stop there, and I think is that okay?
That's
Okay.
a good start. Thank you,
Okay.
Eugene. David, you want to?
Sure. Canada, of course, could do better, but I want to weigh in and suggest that no matter how better Canada can do, it will not likely assuage the concerns of investment arbitration tribunals if they're intent on finding against a host state. And I'm going to point to the recent decision in Clayton in Canada, or the Bilcon case, where a joint environmental assessment review process was condemned by the investment tribunal for denying the investor due process, and ran roughshod really over the very, I think, genuinely serious environmental assessment report that was issued in that case. The tribunal members, 2 of 3, seemed intent on finding against Canada and then awarding damages. We'll learn what that amount of damages will be. So, the standards that investment tribunals are setting in order to comply with the very robust and expansive notion of fair and equitable treatment requires that states meet standards of behavior that seemingly are very difficult, especially in a federal state. In this particular instance, I think we have Exhibit A of how it's virtually impossible to satisfy investment tribunals when they're intent, again, on finding that the state has ran afoul of investment treaty disciplines.
Yeah, John.
Thank you very much. Let me begin by saying that I'm not representing Bennett Jones here tonight. I'm speaking in my personal capacity, and it's doubly important to make this point because I'm not a lawyer, and so anything I say ought not to be taken as being a legal opinion or a legal interpretation. But I have had some experience as an international official negotiating in these areas, so I do have a few views. But and I would agree just with what David just said. I think this case he referred to is a very disturbing case, and I hope we'll have an opportunity to come back and talk about that a bit more later. But first of all, let me pick up on what Eugene was saying, and I think that let me make the assertion just for the sake of argument. But I also think it's true that probably the most important inward investment policy that we have in Canada is the basic framework of laws and economic management that we have in the country. That these are the sort of things that are really going to determine whether an investor is interested in coming here or not. And these establish also the framework within which any business in Canada and any foreign investor is going to have to operate and respect. Now, I'd also like to say one other thing, and that is, I think it's really important to, just in terms of how important this subject matter is, and how it's increasingly more important, I think. Now, Eugene talked about this a bit, and let me just step back. Getting ready this morning, I thought, geez, I better do something to get ready for this panel. And so I got out the World Investment Report, was one of the things I did from the UNCTAD for 2014. And one of the sort of rough parameters I've always found it useful to look at is, what are the sales of foreign affiliates of multinational companies? How significant are they? Because to my way of thinking, this is a rough measure of what's happening as a result of all of this foreign investment. And so I found a neat little chart, and I'm going to bore you with just a couple of figures. One is that in 2013, which is the last year for which the statistics are available, and these are, the UNCTAD says that these are IMF statistics that they're using in this analysis. So if you compare sales of foreign affiliates with, this is in the world, with world GDP, they account for 46% of global gross domestic product in 2014. That's pretty significant, I would think. And that's up from a figure of 21% in 1990, which incidentally is the year for which the most recent statistics were available when we were negotiating the NAFTA. So it's more than doubled as a share of GDP since then. If you compare that with world trade or world exports of goods and services, the figure for that as a proportion of GDP in 2013 was 31% versus 46% for sales of foreign affiliates. And back in 1990, world trade was 18% of global GDP versus 21% for sales of foreign affiliates. And if you sort of track it through in the intervening years, it's sort of moving in a trend line upwards in that direction. It's not bouncing around. So we've seen two things happening here. A great increase in the proportion of global GDP that's generated by sales of foreign affiliates or by foreign investment, and also that it is increasingly more important as a share of GDP than international trade of goods and services. Now, to me, this is saying something about the world in which we live. This is, the increasing reality of globalization. And certainly these are issues where I think it's not surprising that they're being debated more and more, and we need to be thinking, given this reality, how do we as a country want to participate in this? And this involves our own domestic approach, and I've said a bit about that, and Eugene has, and I think when we get in a bit later, it also involves how we want to think about approaching international treaty making in this area.
Yeah, thanks, Una. I just want to pick up on John's comment about a framework of strong laws. And I think that's right. And I think what we see globally is that foreign investors, when they're looking at locational choices, want to go into a place where there actually are strong, clear laws so they know what the rules of the game are. And I think one of the things that has happened over the last few years in Canada is the dismantling of some of our strong laws, especially in the environment area. And rather than producing easier entry for foreign companies, the impact of that has been the exact opposite. It's created a much higher degree of uncertainty, much more court action that's bound to happen, much more uncertainty as to the results of that court action, because they've taken a set of laws that was essentially seen as legitimate, if not perfect, but at least a broad sort of countrywide sense that they were legitimate, and the impact of the change has been seen to make them less legitimate and more favorable to one stakeholder in a number of cases. This isn't the investment laws per se, this is the other environmental laws in particular that have been reduced in terms of their impact. So I think when we look at the question of a framework of strong laws, reducing the strength of some of those laws isn't necessarily the best way to go about attracting foreign investors.
Okay, thanks. Does anyone want to comment back on any of that?
Okay.
Yes, Eugene?
Since I'm an economist, I feel obliged to throw some more numbers at you. So just just following up, I think, on all those points. So Canada's share of world FDI has fallen from 16% to 3%. So it was 16% in 1970, and it's 3% today. So while I don't think that's necessarily a problem. I think you want to put it in perspective of the size of Canada and the emergence of so many countries. So, great part of China has emerged to 11% of that figure. So it's not a doomsday thing. It's not like, oh, tragic, we've fallen from 16% to 3%. Probably a better metric is to look at the ratio of the share of Canada's FDI, kind of like John's measure on FDI sales. If you look at the share of Canadian FDI in the world relative to its share of GDP, if you have around 1, that means the size of your FDI is about the same as the size of your country. And we're pretty close to 1, but we used to be more like 6. So on the inflow of FDI, we've come off a lot, but we're kind of relative to the size of our economy. Again, I guess I do think that one way to look at this is Canada has lost ground. Canada isn't attracting FDI to the extent that it used to, but I think it's because of the changing economy. But we have the same thing on the outflow side. So again, thinking of both inward and outward FDI, and thinking of it as part of global value chains, and it's part of trade. So trade and investment are intrinsically linked. You want good outward and good inward. We've also declined in our absolute, our sort of share of world outward FDI in a similar fashion. But our ratio is still, it's above 1. It's about 1.2. We do more investment overseas than we have coming in. So anyway, I do think it's at least important to talk about, is Canada kind of doing something right or wrong on that front? Are we lagging behind? I think that's an important question to ask. And then is policy part of that? Anyways, that's kind of my reaction.
Thanks, Eugene. Thanks to all of you. So the next question, and you actually started to raise that, Eugene, with your remarks about outward investment, is actually to focus on the question of outward investment. Do we think that Canada is taking the right steps to promote outward investment by Canadian companies and to ensure that Canadian companies operating abroad act responsibly? Can these economic and ethical objectives be reconciled, or are they perhaps contradictory? Now, who would like to start with that? Is that Eugene? Would you like to comment on that?
I guess, so I kind of just mentioned the FDI outward in terms of our decline. Again, I guess I'm less sort of troubled, if that's the right adjective, by the inward flows. On the outward side, we've declined, but we are also not really engaged in Asia. So our foreign direct investment, if you look at where we're investing, we're not investing in Asia. Now, again, I'm loath to say if that's a government policy issue. I think it's our businesses and our firms and our focus. Of course, we're focused on North America. That's where most of our FDI goes. That's where most of our trade goes, and that's where most of our inflow of FDI is from. But if you look at the regions, we are sort of lacking there. And one of the arguments I would make is that we're lacking a coherent strategy on investment in general. I think, again, if we go down the table, we'll all agree that we might not agree on what that strategy should look like, but I don't think we have a clear strategy. And I don't think we have a clear strategy on Asia. And I think those would be the two parts of it. And that shows up on the outward side rather than the inward side.
Thanks. Howard, would you like to comment on that?
Well, I guess my key concern is the extent to which our outward investment promotion seems to be focused on the natural resource sector and Canadian natural resource companies, and to a large extent that's created what in my view, at least, are some unfortunate situations where the Canadian government is pressuring some of the least developed countries in the world to negotiate investment treaties, specifically to ensure sort of privileged entry of our natural resource companies, often under threat of losing official development assistance if they don't negotiate them, and other kind of political pressure points like that. And those raise a number of real ethical issues and political issues, I think. On the issue of responsibility, I mean, the reality is too many of Canada's natural resource companies are not seen as operating in the most ethical way. And in many cases, the sort of negotiation of investment treaties is being designed to shield them from some of that practice. I think we'd be much better off promoting the industry, ensuring the highest standards of the industry, not just in theory but in practice, and also by ensuring that we ensured the liability of Canadian companies in Canada for the impacts of their decisions overseas. That shielding of liability, Canada is one of the strongest shields for liability for our foreign investors outside of Canada of any developed country, and that has an impact in terms of the degree of responsibility some of those companies exercise.
And just related to that, this isn't an area in which I have a lot of expertise, but the mining ombudsman, for instance, promoting corporate social responsibility in the mining industry has not been entirely successful. Apparently, the ombudsman resigned after the first year of a 5-year term. And then the mining industry itself is somewhat resistant. I was reading a chapter in a forthcoming book by a mining industry spokesperson who was complaining about a failed liberal bill in the minority conservative parliament a short time ago. And so complaining about failed liberal bills seems to me to be placing the emphasis in the wrong place.
John?
Well, I guess let me ask the question, how much should the government be doing to encourage investment abroad or even investment in Canada, and how much should it just be allowing that to happen, or creating a framework with which, through which that can happen? And obviously then you get into various factors that ought to be present or not present in that framework. And certainly some of them are the ones that Howard has just spoken to. But I think it's also probably fair to think that in this world that is extremely globalized, that I tried to describe when I first spoke, that we're going to want Canadians to be actively engaged in the investment business, because it appears as even more important than trade in terms of what's actually being sold in the world. So I think we need to think, part of that framework, I think, has to be a regime of investment agreements that establish sort of the rules of the game in this area, just like trade agreements have done for so long. And of course, it's in my lifetime as a trade official that investment has become now such an important issue. People didn't even, when I did the GATT negotiations in the 1970s in the Tokyo round, I don't remember, there was very little discussion of investment. It wasn't really much of an issue at all. And clearly now it's at the top of people's concerns.
So are you suggesting that investment agreements should include these issues of the corporate responsibility as well?
Well, I think they're legitimate issues that can come up, and even I'm I suppose people might find it unlikely that our current government would consider these matters to be important. So it's interesting to note one thing in the budget document, which is related, if not completely on this point, you know, is the commitment to improving the integrity of federal procurement in the budget. And the budget documents make the point, the government will take action by introducing a new government-wide integrity regime for its procurement and real property transactions to ensure that it does business with ethical suppliers in Canada and abroad. Now, that's a government procurement policy, but I think it's an interesting, it's interesting nonetheless.
Thanks, John. Howard, you wanted to add something?
Yeah, I agree with most of what John said there. In particular, I think foreign investment by Canadian firms, outward investment, is a good thing, or at least it can be a good thing. Certainly when I started my international career, Canada's reputation, in part because of its politics and policies internationally, in part because of the conduct of our companies abroad, was stellar. That's unfortunately no longer the case, and I'm just going to deal with the responsibility side now, not the political side. And I think where we are now is sort of promoting investment treaties with extremely strong protections for foreign investors without factoring in the equal sort of side of the responsibility and the liability when things go wrong, and without carefully linking those provisions to the development dimensions in developing countries in particular, where so much of the natural resource investment goes. And when you're advocating treaties that in fact seek to reduce the scope for those developing countries, including many in the bottom 20 and 30 in the world in terms of human development, to apply development tools to promote the economic benefits of those investments. When you are pressurizing developing countries to negotiate treaties that preclude them being able to do so, I'm not sure that's really the right direction in terms of our best options for foreign policy, for foreign investors.
Thanks. Okay, let's move to the next question. What have we learned over time about international investment agreements? Do they actually encourage investment? Do they assist Canadian businesses to be strategically placed in global value chains? And what are the costs to national sovereignty? And I think David was going to lead off on this one.
I'm happy to begin. I've been very interested in the question of whether signing of investment treaties encourage new inward investment. And it's interesting to note that the empirical studies regarding this correlation only started to come basically online, let's say 10 years after takeoff. If we take 1994, NAFTA's date, only a decade later or within that, late at the end of that decade, did those studies start to emerge. So there was, of course, flood of signing of these agreements without any evidence, empirical evidence. Of course, there was anecdotal, one might say common sense. And what's really interesting is that the evidence reveals, some studies reveal a correlation, others do not. Charitably put, the evidence is ambivalent. There just isn't a knockdown argument that signing investment treaties brings in new inward investment. Even the Government of Canada admits this. This is from the Department of Foreign Affairs International Trade and Development website. It is difficult to measure the economic benefits of FIPAs, the government acknowledges, and then cites one study. There's a very short bibliography at the end of its summary discussion of FIPAs. That is the Salacuse and Sullivan study from, I think, 2007, which showed a very strong correlation between the signing of BITs between the United States and other countries, but then found no correlation between the signing of BITs and other OECD countries. There was no positive relationship. Those other OECD countries would include Canada. So the empirical, even the good studies, the so-called good studies by Salacuse and Sullivan that folks promoting investment treaty norms point to is not actually supporting BIT policy, at least in Canada.
Who else would like to comment on this?
I would.
Eugene, go
Yeah.
ahead.
I guess just because my reading of the evidence is different than that, but it's very much, I think it's debatable. I would say, so I agree 100% that it's very difficult to measure this, and that's exactly right. And that's why the studies are a little bit, I think, what did you say, charitably, they're ambivalent? So I guess I would disagree with that characterization, except that it is difficult to measure. And part of it is because of what John had said earlier. The things that matter are good policies, property rights and certainty, less risk, and things like that. Policies that governments typically undertake before they sign these agreements. Or there's a confounding factor where they often are signing other types of agreements. So they're undertaking reforms, they're doing trade agreements, and they're doing FIPAs or investment agreements, bilateral investment agreements at the same time. So it's very difficult to tease out the causal impact of that. And again, it's a little bit of what came first. The reforms on property rights and rule of law and good governance, did that come before the FIPA or the BIT? In Canada, we call them FIPAs for some reason. Everyone else calls them bilateral investment treaties or BITs, and then I think some people call them international investment agreements, but we're talking about the same thing, I think. These agreements typically are part of reforms or changes that have already been undertaken or are being undertaken. So it's very hard to measure the causal impact. The other part of it is it's a very complex thing. So most of these studies look at sort of aggregate flows, bilateral flows of FDI, and they control for the factors that you should control for that determine flows of FDI at an aggregate level. But FDI flows are more complex than that. There's different motivations or types of FDI. There's market-seeking FDI, there's resource-seeking FDI, and efficiency-seeking FDI. So firms are undertaking these for different reasons, and these policies could affect those different types of FDIs differently. And finally, there's a recent study out where they've taken all the studies, they've taken 33 studies with something like 300 different results of these regressions, and they found that 75% of the studies, of the results, show that there's a positive and statistically significant effect. So I guess I would disagree with your reading of the literature, but I would say that maybe it's not the right question. I do think that these agreements probably do affect foreign direct investment. That's my reading of the evidence, and so I guess I'll leave it at that.
Well, the aggregate analysis of the aggregate studies, all the studies taken together, if some of them are bad, is not going to give you an accurate result at the end. So the question is how accurate many of these aggregate studies are, how difficult it is to isolate relationship between BITs and inward FDI, and I think we're going to end up in stalemate on this question. I think we might want to move on to other questions. It may have an impact, I think, on state policy. You might see some states, certainly no rush to the exits, but you might see some states, South Africa, for instance, abandoning its investment treaty policy because there's just no correlation. You look at counter evidence like Brazil, for instance, through much of the 90s and 2000s, which was a magnet for foreign investment, signed, I think if I recall correctly, 7 treaties and ratified none of them. None of them were in force. So, I think countries are moving beyond this debate to that is about utility to questions about the cost to sovereignty, which is something I think that you raised in your question.
John? And
Well,
Howard?
I guess, I think you're right. We'll not come to an agreement on all these matters this evening, but, and we are seeing an interesting trend in the last year with, and I think Indonesia has abandoned one of its investment treaties too. But nonetheless, the new treaties entered into in 2013 still meant that at the end of 2013 there were more treaties in effect than there had been at the beginning of 2013.
John, it's funny, it does feel like the 1930s.
Yeah. So I think, so there's definitely, there are a lot of countries which are continuing to negotiate these agreements. And I think one of the problems here is if you are a big, prosperous, rapidly advancing country like China or Brazil, and you have a lot of things that people want to invest in going in your territory, then clearly that's going to be an attraction. And maybe you're not going to find investment agreements as necessary in terms of securing investment because you've got lots of opportunities knocking on your door. The problem is probably different for some of the smaller developing countries who are maybe hoping that, somebody's going to decide to invest in something in their country, and they're going to feel more compelled to have an investment agreement and provide assurance about how that investment is going to be treated because they're competing with other parties to get that, and they'll see that as important for their economic development. So I notice from having gone through the World Investment Report for 2014 quickly, and I sort of looked through the policy section, that one of the themes in there now, and this wasn't quite the case a few years ago from UN organizations, was sort of wondering whether there should be a move to a multilateral investment approach. And I think in that context, they mean really multilateral, not OECD multilateral like the MAI. Because then you would have, if you could go down that road, and I think there'd be a lot to be said for that, you'd have an even standard of investment rules applying across the board rather than variations in individual treaties. And well, maybe we'll get into that in a subsequent question. Our time isn't quite up yet, is it?
No, you still got a
No.
bit of time. And Howard, you want to make a comment?
I think there is going to be a need at the end of the day for some kind of a multilateral approach to this issue and to resolving the problem of the inconsistencies and a number of other questions and some of the real impacts that are continuing to emerge on sovereignty. Where that should be located is a different question, but I think there is going to be a need for one. And I think it's going to have to start from the perspective of a holistic look at all the stakeholders, the rights and responsibilities of all the stakeholders in the investment process, and not start from the perspective simply of the rights of one stakeholder in the international investment process, that being the foreign investor, the capital owner. We're seeing growing impacts of that in terms of a disequilibrium in international economic law more broadly. We're seeing in terms of the structure of these agreements where they're really being geared in the context of the debate on the 1%, the richest companies and individuals, really geared to support the interests of existing stakeholders at the expense of a diversification of wealth or more equitable distribution of wealth. These agreements clearly support the continued rights of existing wealth owners in the foreign investment context, and a number of other issues related to sort of global socioeconomic and socio-political or political economic issues like that. And I think in terms of the impact on sovereignty, and here's where I really wonder if we're learning, there's a lot of talk about adjusting the existing investment treaties, fixing the language to reduce the exposure of governments to wayward decisions of investment tribunals, investor-state tribunals, ensuring that governments have a higher degree of certainty in undertaking different regulatory decisions and applying them. And then we come to a situation like the Bilcon case that David mentioned earlier. This is an environmental assessment case in New Brunswick initiated by a company based in Delaware attempting to undertake a quarry operation. And the impact of that case is really stunning what the tribunal, in a 2-to-1 decision in that case, did was gut the independence of an environmental assessment tribunal. I want to be really specific. The environmental assessment process in Canada, as it is around the world, is based on the assessment process being entirely independent from the rights and roles and responsibilities of other officials in any government in Canada. It's a check and balance on their function, on how they work to promote investment. It has to be independent. And by using this so-called doctrine of legitimate expectation through the NAFTA, and there's a specific paragraph, I think it's 444, where they discuss the foundation of their decision, they've essentially said all the conversations and even the fact that the province of Nova Scotia was advertising it was open for business have an impact on the independent ability of the assessment panel to reach its own decision. And when you look at that, it's really quite stunning in the impact of that case. The problem is the foundation of that decision is almost identical in language to the text of the Canada-EU trade agreement on the same issue of fair and equitable treatment, meaning all of the discussion that CETA will inherently protect regulatory space more is really open to real serious debate. And it's through the exact same language of legitimate expectations, which many critics of the text of the agreement pointed to at the time it was being drafted in the leaked text, and the open-ended nature of the language of legitimate expectations in that treaty compared to other language on other issues. And that's how we see the Bilcon case built, and that's that lesson I'm not sure has been played through. Well, I mean, CETA was drafted before the decision, so we'll have to see if it plays through in any further legal cleaning up of the text.
Okay, so we have one last question I'd like to put to you, and then we'll open it up to the floor for further questions and comments. You've raised some interesting questions about the points about the evolution of people's thinking, states' thinking about these different investment agreements. We've had NAFTA for 20 years. Very little interest in the 3 NAFTA countries doing anything exceptionally new with NAFTA. Big decision you referred to, Bilcon. Quite a shot across the bow of people's expectations for these systems to work as they would hope. So what do you think the emerging critique of international investment agreements and investor-state dispute settlement processes actually signifies for Canada? Whereas Canada was fairly secure or confident that the CETA was going to work for us, we know that in Europe there's been many questions about it. Where is all this leading, and how can Canada position itself to lead constructive reform and take advantage of constructive reform? Who would like to open up for that? Is that David?
Sure.
Thank you.
I can be everyone's punching bag, or actually, Howie is. So we're at a really interesting time. ISDS, everybody's become familiar with the acronym, right? Congress is deciding whether to grant President Obama a trade promotion authority to negotiate the final terms to TPP, the Trans-Pacific Partnership, and ISDS is very much on the table. Germany might throw a wrench into the system. Now, we've seen these kinds of sort of crises, in scare quotes, before, moments when the legitimacy of investment treaties and investment arbitration were at issue. The fact that Germany might withdraw, for instance, from CETA, insist that ISDS be removed, for instance, if the Social Democrats have their way, and there's no certainty of that, could be a serious pitfall for the continual evolution of the regime. I see it as quite durable and intended to be durable, that is, be enforced for quite a long time, and it's constitution-like in that way. So we're at a really interesting time, and the question is what Canada can do in these circumstances. And my recommendation is that we consider promoting Canadian values in our investment treaty policy. What are those values? well, in fact, we don't have constitutionalized property rights, except for Aboriginal peoples, actually. There are no constitutional property rights in Canada. Canadians gave to themselves in 1867 and then again in 1982 a great deal of policy room because we needed active state intervention in the construction of what was to become a single Canadian market. States were active in constructing that market. And it's entirely hypocritical for us to go abroad and insist that states abandon these kinds of policy tools that will help them develop. And so why not channel Canadian values instead of US priorities? In the latest iteration of the Canadian model FIPA, we incorporate standards in regard to the qualification of what counts as an expropriation. We've incorporated standards articulated by the US Supreme Court. We're channeling US constitutional policy. So I think I'd like to see Canadians channel some of our own priorities and values abroad.
Thank you. John?
Well, one of my first brushes with investment policy was when I was the director, I think, of the GATT division in the Department of Foreign Affairs and International Trade, and I was told that my job was to defend FIRA against an American challenge in the GATT, which was a very interesting process. But the point I want to get to here is that a lot of the sort of policy space issue is it's not really about expropriation. I mean, anybody can expropriate something if they're prepared to offer compensation and it's for a legitimate public purpose. But the policy space really comes from the area of what's been now put in TRIMs. You know, what are the sort of investment incentives? And what the Americans back in 1982 were complaining about our Foreign Investment Review Agency was that we were negotiating undertakings with companies that were investing in Canada, and we were getting them to agree to domestic production commitments and export undertakings. And then they would voluntarily agree to this in a discussion with Investment Canada, and then it would become binding under law. And so this was found, you know, it was very interesting. Actually, Canada won on the export undertaking. That was not found to be a violation of the GATT as it was then. And we lost on the domestic production requirements because that was seen as being a violation of GATT Article 3 on national treatment. So I'm not sure, you know, it's not a straightforward thing thinking that all of the disciplines relating to countries' freedom to benefit from investments are in these investment treaties. Some of it's already in the various trade agreements under Article 3 and subsequently now the Trade-Related Investment Measures Agreement in the WTO. But I do think that there, you know, notwithstanding what's just been said, I think there's been a significant evolution in the thinking of governments in the last few years about how international investment agreements, BITs, FIPAs, should be structured. And you see the language is significantly different in the CETA from the NAFTA, for instance, in terms of fair and equitable treatment. It's very different in terms of the description of what sort of public policies don't give rise to claims that an investment has been expropriated and that's very significant. And I think actually when you read it, it's the intent of the meaning is very clear. Now, whether the language is the same as what was in the Bilcon case, I've already said I think the Bilcon case is very disturbing. I reiterate that. And I'm sure, I mean, it only came out in what, March? I'm sure that this is going to continue to play out. And of course, we don't have the arbitral award yet, or
Damages award.
Damages award. Mm-hmm. So, you know, that's a second part of the process, and we'll see where this all all leads, and I must say I'm not even legally familiar enough to understand whether is there any remedy that can be followed under UNCITRAL to already to appeal this. Anyway, the other thing I want to make is that there are a number of new ideas out there also on the procedural side in terms of improving investment agreements, making and definitely in terms of the thinking of the EU, which we will probably see reflected in TTIP, because I think when you look at what is coming out of American policy now, and I was interested to see, in the Trade Promotion Authority that's now in front of the U.S. Congress, if you look up the objectives, there's a section on the objectives for investment, and one of the parts of that is to make a negotiating objective of the United States providing for an appellate body or similar mechanism to provide coherence to the interpretations of investment provisions in trade agreements. Now that's quite significant. So, does that mean that when the U.S. negotiators come back, assuming this thing passes, which I think is still very much a question mark, that the U.S. negotiators come back with a TPP agreement to Congress, they're going to have to show where the appellate mechanism is? Does that mean that we will then, because that's in a treaty between Canada and the United States, we will then have an appellate mechanism between us that wouldn't apply retroactively, I guess, but would apply to future cases? There's some very interesting things here that we're going to have to sort out in terms of if TPP really moves forward as to what is going to govern the relationship, which provisions in NAFTA or TPP, or that all has to be resolved. We had a whole other panel on those sorts of issues, I remember. But so I think there's a lot of change going on here, because I think that, there's a lot of people in government have become more responsive to what the critics are saying and recognize that a lot of this is correct. I must say, when I finished the NAFTA negotiations, I obviously wasn't the person doing the investment chapter personally, but I was following it quite closely because it was one of the more controversial parts of the agreement among the countries. I thought it would be publicly more controversial immediately, and it wasn't. As you say, it sort of took 10 years for people to analyze what was going on. I went to a press conference the day we released the text of the agreement. The minister did one, and then I was asked to go and give a more technical briefing. And my biggest worry was I was going to be asked a series of questions about what the meaning of the investment provisions was and the implications of that. And nobody asked anything about it.
Well, there's still a disinterest, actually. During the CETA negotiations, it was really difficult to get any of the Canadian press interested. There were leaked drafts. There were commentaries on the leaked drafts. Couldn't get any interest in major Canadian newspapers.
Well, even in the MAI and the OECD, which eventually, of course, exploded in public controversy, I remember asking a senior Canadian negotiator, I was then posted in Geneva, I said, what did you put in the cabinet memorandum under the section that I knew was required that said, what are the communications implications of this? And he said, I'm already giving the sex away, that we put in that there were no communications implications. Anyway, sorry.
Okay, quickly, Howard.
Yeah, but I think that was largely true. I mean, the negotiators in the OECD context of the MAI simply had no clue about the impact in terms of public engagement of what they were doing, and were entirely shocked when it exploded on the public stage. But let me go back to one of John's comments that the language is different, and sure enough, in the specific context of fair and equitable treatment, the language is different. But when you look at the Bilcon case, and when you look at the provision in the CETA, the foundation of the FET, the fair and equitable treatment ruling, that is the really explosive one for most observers of the Bilcon case, is virtually identical to the approach in the CETA, to the language in the CETA. There were significant public concerns raised by different commentators about the particular language on legitimate expectations. The negotiators concluded that. They took out another provision which Canada had wanted, which would have been even stronger rights for investors, but the Europeans, as far as I understand, the process balked at that. But that particular provision on legitimate expectations was left extremely open-ended, and that fits in precisely with how CETA could be used exactly the same way as this tribunal did in a future case, whether it's environmental assessment or otherwise. It's extremely open-ended, and at the end of the day, very subjective, including things like public advertising that the province of Nova Scotia is open for business as one of the legitimate expectations for a certain result of the environmental assessment process. So I think there's some real issues, and the fact that the language is different, and I agree it is, doesn't mean that the impact is different, and a lot of those technical terms in the drafting of the treaty really need to be very carefully reviewed. And then you do have a lot of the language that is the same. There's the provision in NAFTA, for the geeks out there, Article 1114 of NAFTA, which says very clearly environmental lawmaking is subject to the full terms of the agreement of the NAFTA. Well, that provision isn't in the investment chapter anymore, but almost sadistically, it's in the environment chapter of CETA. I mean, the same language is there, the precise same language is there. So in some cases there's been changed, in other cases the exact same language and approach remains. And I think in terms of the broader issue of where's the debate going and what kind of leadership can Canada show, I mean, the current trend, and Vern McKay was very clear in it, he was chief negotiator on I believe on the Canada-China agreement, or one of the negotiators, and he had to testify in court as to why a particular provision was written how it was, and he said because it gave Canadian companies greater rights to challenge the government in China. That was his testimony, and the impact, of course, was that it also gives Chinese companies greater rights to challenge Canadian government action vis-a-vis Chinese companies. So the government is prepared to make those kinds of trade-offs in the negotiation. It seems to me that we need to be rethinking that, and we need to be rethinking the purpose of these agreements. Sorry, if I can just take sort of 30 seconds. When the agreements began to start in the late 1950s and 60s, there was a tremendous fear of the impacts of decolonization and the impacts of the potential expansion of communism, right? A few years after Hungary in 1956 and other things like that. So we know the purpose was developed to protect capital in those contexts. Whether we like it or not, there's a rational basis for that kind of singular approach. It seems to me today we need to be rethinking the singularity of that purpose of protecting one stakeholder and looking at a combined set of rights and obligations that really reflect the interests of all stakeholders, and especially those in developing countries who have the least developed legal systems now and often have the biggest impacts in terms of these agreements constraining their ability to develop more robust regulatory practices and more robust regulations in order to ensure that the investments they get really do contribute to their own development. That's where we could play a lead role.
Thank you, Harry. Eugene, I think you get the last word. Until the questions start.
Okay. Well, I guess, so the question was, what should Canada do, I guess? I don't know, if you look at, I mean, certainly the Bill Con case and cases like that are very disturbing and raise, big red flags, and we have to be very careful about this. I went and looked at some of the evidence on, how many cases are there? Is it real? I guess my big problem with this debate or literature is people say we got to get rid of these things, or other people say they're okay, don't worry about it. Or actually, it's hard to find people that say that. But I guess I don't know what the solution is. I think that the answer is they are a big mess. The big mess is there's 3,200 agreements out there with almost every country. I think 200 countries have these agreements. They're all bilaterals. Not all of them, but many of them are bilaterals. And then and they're overlapping. And I mean, it's a real mess. And And then the provisions or the legitimacy and the kinds of concerns that come up with some of these cases, these are important concerns and important problems with these. But again, if you look at some of the reports from UNCTAD, their focus is on let's try and fix these things, let's try and make them work better. And I just don't see Canada stepping up and playing a role there. I think that's a real problem. So Canada is not playing that leadership role. John mentioned the idea of doing something multilateral because maybe, it seems maybe from the trade perspective that in the old days when I was a graduate student, the big debate was are bilateral trade agreements a problem for the multilateral system? And it turns out they were and they are in some sense, but the bilaterals are, we talk about the spaghetti bowl of trade agreements, the investment agreements I think are much worse, and then the provisions of them. And so I don't know what the fix is, and I think that's what the focus should be on. How do we make these things work? Because I do think they're important, I think they're relevant. And I'm not sure they're as loaded on the investment side, as at least in the outcomes. I think there's 600 disputes out there, and the findings aren't, very few of them, or most of them, I think a third of them are in favor of the state, and a third of them aren't determined, or they're settled out of court. So, there's issues with transparency and legitimacy and process, and probably we'll talk more about that, but I think they need to be fixed. I have no idea what the solution is. I'm an economist, so I don't know. I just don't want to say leave it to the lawyers, because I think they got us into this mess in the first place. But
That's for sure.
And thank you for bringing some numbers to the discussion, so that it forces the lawyers to come to terms with their opinions as well. Okay, so we had a wonderful discussion of this from Eugene, Howie, David, and John. And I'm just wondering, would any of you in the audience like to pose some questions or make a statement about any of these issues? There are microphones here. If you could go to the mic, that would be very helpful. Thank you. And I see one person at the mic already.
Hello.
Go for it, Sylvie.
Let's see. I don't know. Okay. My name is Sylvie Tebet. I'm director of the Trade Law Bureau, and I do a lot of these disputes that you guys have been referring to. In fact, my question didn't refer to the Bilcon case, but I was surprised that in the discussion about Canadian investment law and policy, we didn't really talk about the Investment Canada Act. And so I was curious about why that is, given that it is one of the main tools that Canada has to review foreign investments in Canada. And if you had any comments on the fact that through its trade agreement and recently in CETA, Canada agreed to an increased threshold under which it would not review investments from Europe.
Thanks, Sylvie. John, would you want to comment on that? Or?
Well, I think there was a reason I didn't talk to it, as I'm not familiar enough with it anymore. But that's why we're going to have Ailish on the panel.
That's true. We have to reconvene the
But
panel.
I think, I think we've lived through a whole history of sort of different government approaches to investment and investment policy in Canada. So when Herb Gray, conceived of and then got the government of Pierre Trudeau to create the Foreign Investment Review Act and Agency, which is now the Canadian Investment Review or whatever it's called, it was a very different world, and we felt we were being inundated with investment. We weren't really worried about courting the world for investment because we thought, we've got enough. So how do we prevent ourselves from being taken over, and what do we do to maximize the benefit for Canada that we get through sort of regulation and negotiation where the government played a big role? How do we go about doing that? And we put the threshold review very low so that we'd be able to bring these policy instruments to play. And of course, that created a lot of frictions with our major partner to the south. And gradually over time, the world changed too, so that, we didn't find investors knocking our door down to the same way that was happening back then. A lot of other countries began rapidly developing, and suddenly, we sort of changed our policy approach for how we should think about these things. Not only that, I think, when we got in on some of these big sectoral questions, I see Conrad von Finkenstein back there. I think, why do we have all these restrictions on investment in the telecommunications sector, for instance? This in the 21st century, this is like steel was 60 years ago in terms of what makes an economy work. Why would we put all these restrictions on investment by these companies, which has subjected us, the idiocy of having to deal with Rogers and Bell and anybody who's tried to get their telephone adjusted, it just drives me nuts. So I think, I'm not sure why we have the Investment Canada Act any longer. Do we what do we need it for? I mean, I'm sure, we need it for some things, but I don't really see it as a major government policy tool in the way it was designed originally.
Did you want to comment on that?
Yeah, so just, I actually think, we really need to think hard about the Investment Canada Act. Again, I agree with what John was saying, but the most recent changes to it were to create a great deal of uncertainty and I think to really negatively affect investment in Canada by going after state-owned enterprises. Okay, so I think we have to have a debate about how we treat state-owned enterprises, but so I'm sure everybody knows, but when the Chinese state oil company CNOOC wanted to buy Nexen and the Petronas deal was on the table, the federal government approved those deals, but then they changed the rules just for a particular type of investment by particular types of firms. They changed the framework of what they consider to be state-owned enterprises. There's uncertainty there. They gave greater discretion to the minister on that. So there's uncertainty about what a state-owned enterprise is. They changed the thresholds for that particular sector, and it was really it wasn't even just the energy sector. It was the oil sands. So it's a very specific piece of legislation. So now we have an Investment Canada Act with all kinds of unintended consequences. One of which was to create uncertainty in the investment field. But I do think this is part of a bigger failure of not having a strategy on Asia and more broadly an international strategy. So we don't have that. And this is part of that failure.
Just on that specifically, when you actually speak to the Chinese and those who manage much of the outward investment from China, their bigger concern is not the Investment Canada Act or the review threshold. Their biggest concern when they're talking about investing in the natural resources or in the oil sands, or as some of us call it, the tar sands, their biggest concern with the investment in the tar sands is there's no way to get the oil to their markets efficiently, and they can't rely on the trains forever. And unless the pipelines are built, and there's no risk in the foreseeable future of those pipelines being built because they're all tied up in environmental litigation that's going to last for who knows how many years. So I agree with you, there was some uncertainty injected through the revisions in the Act. And the threshold issue that Sylvie raised, I mean, in terms of the upward threshold in Europe, I don't know how we keep that just to the Europeans, given the requirements for MFN treatment and all the other treaties. So it's really raising it for everybody in a practical sense at the end of the day. I'm not sure how we can justify otherwise. But in particular in terms of the oil sands, tar sands investment, the bigger issue is elsewhere.
I think what I'll do is, there were a few people who wanted to ask questions. Could you ask your questions all together, and then we'll have the panel respond to them all? Okay, thank you. First gentleman.
Hi, my name is Maxim Bertuchevsky. I'm also from the Department of Foreign Affairs, Trade and Development. I actually have a couple of observations, if you'll permit. I'd like to pick up on one point made by Howard Mann and one by John Weeks. So to the point about Canada pressuring lesser developed countries and linking negotiations to ODA, I've had about half a dozen international assignments abroad promoting Canadian trade and investment, and I can attest from a field perspective that Canada is probably one of the worst countries in the world in terms of ability to link issues and get something for the benefit of our companies and investors. So just empirically, I have not found this to be really, really reflected in a Canadian reality. And the other point about going to multilateral negotiations, I think if you look at countries where that do not have a lot of international investment agreements, any major investment there, particularly if it's natural resources, especially if it's natural resources, always contains international arbitration clause. You look at mining countries in Central Asia like Mongolia, Kazakhstan with oil and gas, countries in Africa. Any multinational company coming to invest will always have an investment agreement with international arbitration clause built in. So if you actually look at those agreements, there's even much more of those than there are bits out there. And you could sort of build this gradual chain from individual sort of retail level almost agreements to bilateral agreements that sort of regularize investment relationships, at least within the confines of a particular host state. And then if you take that further and you look at TPP, you look at TTIP, and you look at ASEAN investment agreement, I mean, this is the next step. So, you know, having something akin to WTO, but on the investment side, may take a very long time if we ever get to something like this. But I think we're already making those incremental steps. And when, you know, with TPP and TTIP, assuming they do happen and come into force, and ASEAN, you have essentially, what, 80, maybe even more % of world investment relationships already covered. So perhaps we're not that much further away from where you think we need to be already.
Thank you.
Thank you.
Okay. Take your question too.
My name is Jean-Maurice Jossou, and I'm the author of L'Afrique, le GATT et l'OMC, un territoire douanier région commerciale at les presses de l'Université Laval. Ambassador Weeks talked about Tokyo Round. He referred to Tokyo Round, and yes, indeed, he was involved in negotiation at that time and later on. But in the 17th, with the Tokyo Round, what was at stake was non-tariff barriers. What was at stake was the structure of international law. And the structure of international law was changing. And what was at stake at that time was also the relationship between North and South, between developing and developed countries, and the enabling clause and the graduation clause has been drafted at that period. So investment was not on the order of the day. But as you witnessed, later on, investment became part of the negotiation, and with the trims during the Uruguay round. And at that time, it was the changing nature of international law, which was the concern of the participants of the system, to the system. So the changing nature of international law, which brought into the framework of global trade, intellectual property, and services, and that brought WTO, that which evolved in 1995. And in 1994, in December 1994, I was in Geneva, and Special Advisor Akel Linden at that time told me about the discussion he had with the Director General of World Tourist Organization relating to the name of the new organization. Will it be World Trade Organization, and the same acronym with World Tourist Organization? But they did have a gentleman agreement, and they said that so with WTO is going to be WTO OMC, and with World Tourist Organization, it will remain as it was. So just to say that at that time, it was the changing nature of international law, so it became it became global. So it is a World Trade Organization. But currently, the focus is on sustainable development law. And I noticed that it was absent from the discussion. I wonder why. That's my question. Why didn't you discuss sustainable development when dealing with investments? We know that this year there's going to be a debate about this in New York. Yeah, we do have the Sustainable Development Goals, which have been discussed together with the DDA. So investment per se is important, but there's also sustainable development. As if we refer to history, the concern at a certain moment was not in my backyard, but currently the concern is about what's going on. How are my concern taken into account? And the sustainable development is the framework through which those concerns are taken into account. Thank you.
Thank you. Last question.
My name is Shirley Palliser. I'm a law student at the University of Ottawa. I would like to know if John and Howard could please elaborate a little bit more on the multilateral investment that they shared with us. Like an example, in GATS we have MOL 3, that is investment for services. So I would like to know if it would be something based on that, then extended to goods. And also I would like to hear from you, have more experience, if that would help stakeholders, claimants, when they come to international tribunals about an MFN. MFN interpretation, we know that it's very inconsistent, and that brings a lot of unpredictable results to claimants. I have an example here, Vanessa Ventures in Venezuela. Vanessa Venture is a Canadian mining company. This case was decided in 2013, and they tried to invoke MFN. It was very unpredictable, the result. So I don't know if having a multilateral investment treaty would help claimants to have a better prediction about MFN interpretation. Thank you.
Thank you. Okay, we have one more question here. Thank you. You don't want to go? You can.
I just want to thank the panelists. I think it's a very, very interesting exchange of different ideas. My name is Nicolás Lloreda. I'm the ambassador of Colombia here in Canada. And I just want to add a couple of things. One is that in my particular case, in my country, Colombia has benefited very much from Canadian investment. It really has. Even before we had an investment chapter in our free trade agreement that we now have. And I think one of the things that we like to mention about this investment, it has been in mining and oil and gas and banking, and that especially came when nobody, or very few countries and very few capital from the world was coming to Colombia. And a lot of Canadian companies decided to risk it. The conditions on the ground were not that safe. It's very different now, unfortunately. And many of the Canadian companies, not all of them, but many benefited immensely. But the government benefited even more because the royalties and the taxes that the company has received from this investment has allowed the government to spend heavily on social programs. So there has been many very positive effects because of the investment. Now, as I said, and a gentleman here was mentioning also that, especially when you're talking about oil and gas, even if there is or there isn't an investment protection, the agreement itself covers it. And what investment agreements, in my experience, and I did some litigation many years ago on investor state arbitration, you can't measure them because by thinking that a company just before investing is going to decide to invest or not in a country because there is an investment agreement. You have to measure the importance if the company, once it has a problem, and if there's something common to developing countries where many of the investment goes, is that the rule of law is not very strong. It depends, of course, on the level of each country. But you have to measure the value of the investment agreement and the value of the bilateral investment treaty. If when the problem appears and when the dispute appears, the company, the investor, the good faith investor, really has another claim, has another possibility something valid to go to an international tribunal and eventually get compensated? And I think that the question I would like to pose to the panelists is that we are at a moment in which we have countries like Venezuela, like Argentina, that have received many, many judgments against, and I think we are back to the 60s days that originate this, about real expropriation, not indirect expropriation, but real expropriation going on in the world. And the question is, what happens if these countries decide not to pay, which is what is happening in many places. Countries decide not to pay. They do not pay the judgments. And what is going to happen to the system? I think that's a question I'd like to hear. Thank you.
And we do have one other question, sorry.
From the University of Basel. And my question is just one of noting that you talk a lot about investment protection agreements, you talk about ISDS, and it seemed almost implicit that any investment agreement would have ISDS. And I'm just wondering if if you would also consider that maybe you should have an investment protection agreement, but without ISDS, if that would resolve some of the worries of those of you who are worried about it, and yet offer the same possibilities for those who think it's not.
Thank you. So we've had some excellent questions and points made, and your challenge now is to respond fairly to all of the questions and comments.
And quickly.
And quickly, because people know there are drinks outside.
I'll go quickly. I don't know if I can hit all the points, but
Okay.
when we were talking about some of the impacts on sustainable development, and I guess I started thinking of Colombia because I've had the opportunity to go there and to see some of the activity that's happening. And again, I think earlier I said, when you're trying to look empirically at impacts, Colombia undertook a lot of changes, their investment laws and rules, and that actually predated the agreement with Canada. But so anyways, I was thinking of Colombia, and I was thinking about the positive spin-offs and the positive impact that, and this is Canadian investment, and it's service companies, service firms, engineering and other kinds of service firms in the resource sector. I don't know what happens if they don't pay. I guess I have the same kind of, when you look at trade policy and countries don't really sort of honor the sort of impact from breaking those rules, we have the same kind of thing. But it does lead to some concerns about sort of the legitimacy of the whole operation. I didn't know about all these agreements or all these investments having their own separate agreements. So I have some questions about that, but I'll save that for a drink. That's all I have to say, I think.
Thank you very much, Eugene. Howie, you want to go next?
Oh, sustainable development.
Oh,
Howie
go
will
ahead.
talk about that.
Okay.
Yeah, in terms of the first question that was raised in terms of Canada pressuring some of the least developed countries to negotiate under, in particular in terms of threats, for lack of a better word, I'm not sure what lesser word there is there that's accurate, of withdrawal of ODA or suspension of ODA. Look, I get that direct from senior officials in those governments that Canada's been negotiating with, and virtually without exception over the last 3 years in East and West Africa. That's where I get that from. It is certainly not something I could have made up or would ever have expected to hear from a Canadian government. In terms of the international arbitration and investment contracts, that is in fact one of the alternatives we often look at in the context of specific investments. But there's very, very important differences between those arbitration clauses in the specific investment contracts and the arbitration under the BITs. They're specific to comprehensive, negotiated, holistic agreements that include rights and obligations of both sides, that reflect specifically the development needs in most cases today of the host country, rather than putting provisions in place that block the implementation of those development instruments They don't have general open-ended language like fair and equitable treatment, which is very subjective and open to very different interpretations, really depending on who the members of the tribunal are. And I think most people recognize that that's the situation now. So that the context for those arbitration provisions is really very, very different than the context under a treaty, and the scope of arbitration under those provisions is much more constrained. In terms of relation to sustainable development, for me, that's what I mean if I didn't articulate it right when I talk about rights and obligations of all parties in the stake in terms of the investment relationships, including communities and civil society representing the interest of not the government or the investor per se, but other interests, and including the liability of investors as well as rights and obligations. Certainly from the perspective of my organization, the IISD, we put out a model international agreement on investment for sustainable development in 2005. So we've been promoting that approach for many years. In terms of extending the GATS Mode 3, I'm not sure if that would have helped a particular situation in one arbitration or not, but I would argue that's an extremely dangerous approach to extend Mode 3 to goods. Mode 3 of the GATS, the General Agreement on Trade and Services, is very specific on rights of entry. It doesn't have anything to say about the conduct of the investment once it's concluded or any other elements relating to those issues. And it includes a provision seeking stronger domestic regulation, limiting the ability of governments to regulate investments either at the point of establishment or after. Now, Canada and the Canada-EU agreement actually includes a chapter on domestic regulation that reflects the EU and Canada approach to that, and applies it to investments in all sectors. And frankly, nobody has any idea how that's going to work when that comes up in the investor-state dispute settlement context. It's a very open-ended chapter, 3 or 4 pages long, but extremely open-ended, and in my view, extremely high risk, and not really well thought out in terms of what the potential implications of it are. So I think it's very difficult to go from Mode 3 and the restricted circumstances of Mode 3 and sort of extrapolate that could be just brought forward across the board to investment in all sectors. I think I'll stop there and leave the floor to others.
Thanks,
although
Alan.
the questions are not any less important.
Okay. David, do you want to pick up on
Sure.
some of the questions that have been covered last?
Just very briefly, are we moving toward a multilateral regime? That's interesting. Stefan Schill has been arguing that by reason of most favored nation treatment, MFN, we basically have a multilateral system in place because we have common reference points and language in treaties, but of course these are continually changing as we've heard today. A multilateral agreement might be marginally better than the status quo, but I want to express my concern. I fear it will consolidate the problems that we have. So I'd rather rethink rather than just move towards multilateral. Sustainable development, sure. You know, Howie's organization has been talking about this for a long time. Now everybody else is, in fact. There was no need to mention it. You know, institutes are rebranding themselves as interested in sustainable. It's everybody's embracing sustainable development, and so you could imagine that it means a lot of things to a lot of different people. Great success story in Colombia. The question is whether a FIPA was necessary, right? And if investors believe that it's going to protect them in the case of some risk, it might be illusory. We haven't talked at all about the costs of investment arbitration. I'm reading recent data, $4 to $8 million to run a piece of litigation, taking 3 years, 8 months, almost 4 years. Not efficient, largely illusory. Lastly, FIPA without ISDS. The US-Australia Trade Investment Treaty is a precedent, I suppose, for this. And if we move in this direction, I will take up my other subject, constitutional law.
John, you get the last
Well,
one.
I think a lot of questions have already been answered, so I'll really concentrate on 2 now. And by the way, I think this is such a good discussion that you could have this every week. And then we could sort of work through it piece
Yes.
by piece. On the question asked by the Ambassador of Colombia about, what happens when people don't pay, that's a very good question. I note, though, the two examples are Argentina and Venezuela, which are sort of particular cases at the moment. And it's not only in investment disputes that Argentina is not paying. So
Right.
I don't think that's going to be what determines the future of the system. But I do think that there is a lot of new thinking going on. Governments are responding to some of the legitimate criticisms that have been raised. And I think we're going to see evolution of how these agreements are structured, including probably reform of some of the existing agreements. So talking about whether the multilateral route's the right route and these other issues, I think are very topical and valuable contributions can be made, including thinking about, what stamp we want to put on it from a Canadian perspective. I guess I'm not aware, maybe it's because of the way things seem to be somewhat tightly held sometimes by our government these days. I'm not quite aware of how we're responding to what's going on, but certainly given the flux out there and the change and the fact, the EU is basically inviting reopening some of these issues in the CETA. Maybe we should be taking them up on that. Anyway, and on a bit without ISDS, well, that's a possibility. You better listen, I'm answering your question. On a bit without ISDS, I think that's unlikely. Of course, you'd then have the interstate provisions of the trade agreement, if it was in a trade agreement, would of course apply to the investment chapter as they do now. You'd just be taking out the right of an investor to pursue it independently. I think the problem is we've sort of let the genie out of the bottle on that now, and frankly, if it required having your government espouse your claim, probably they just they wouldn't bother because, it's too expensive having all those lawyers in the Department of Foreign Affairs and International Trade.
So if the Germans win, let's say, in Europe, and say, we'll do the CETA, but without ISDS, you think Canada should say, no, why bother? Or would that be, yeah, why not?
Actually, stay tuned for
It's a good
another
question.
conference that we're going to be holding on this very topic.
By the way, do the Germans have ISDS provisions in their bilateral treaties?
They were the first out of the gate, the late 50s.
This is a question of, and this we didn't talk about, but this is really saying, and this was sort of discussed in the NAFTA. We don't need ISDS provisions between Canada and the United States. We've got established systems of law and so on, and we just need it for dealing with those Mexicans. Well, you can't have a world regime. So each year we'd sit down and determine who are the people with whom we're prepared to have. We'd have a list of people with whom we need ISDS provisions and people with whom we don't.
Except that
Okay,
the
listen,
justification
guys.
for,
We're gonna stop.
but
Howard,
the justification.
You'll have a chance at the other conference.
But the justification for ISDS was precisely because the judicial systems of the developing country partners were so incapable of dealing with the issues properly that you had to have it. If that justification isn't there, then why do we have it?
And- Okay, so as I was saying, let me just, we have to close this down because we spent money on drinks and we'd like you to get to this, okay? But we are doing a further session on investment and investment agreements in September. So stay tuned, you'll get notice about that. I think September the 25th, it's an all-day event. You have raised, panelists, thank you very much. You have raised wonderful issues, so has the audience. Clearly, this is a very exciting time to be looking at global rule of law issues. And there is an opportunity, it is a time of crisis where there are opportunities to think about new ways of doing things. So thank you very much for participating. And I think that Stephen would like to say a couple of words shortly, very shortly, so we can then proceed to a drink. Thank you.
Thanks, Una. So I'm from the World Trade Institute in Switzerland. I live in Europe, in other words, and in Europe, as Krista also lives in Switzerland, was implying, the whole issue of investor-state dispute settlement and investment agreements has really become one of the hottest political issues. And from the discussion this evening, I can see that Canada is heading down the same road rather rapidly, and I think that's very good. I think that's a very important discussion that needs to happen. And so, you know, I find the discussion this evening very positive in that way. Although I have to say that as soon as you start talking about these legal issues, I'm not a lawyer, but as soon as you start talking about these legal issues, they tend to take over the discussion rather quickly. But nonetheless, I think tonight's discussion as a whole really did reinforce the two issues about the philosophy underlying the diploma that my institute, the World Trade Institute at the University of Bern in Switzerland, and the Faculty of Law here in the University of Ottawa are going to start from next year. And that is the two issues that I just want to mention are firstly that there is an important need to reinforce the diversity of policy instruments and legal instruments which regulate investment around the world, both, I think, in terms of attracting investment and equally importantly, although it wasn't discussed as much this evening, managing the impact of that investment once it has entered new countries. And secondly, diversity in terms of the stakeholders in the investment world. I mean, I think Howie particularly made this point strongly this evening, and I'd like to reinforce it. It's not just about the investors, it's about a whole myriad of other stakeholders in the societies and the economies, and that's what we are trying to emphasize in the diploma that we're going to be starting next year, which is going to be about training people in the investment world to think about these issues in a much more rounded, interdisciplinary way, not just as lawyers, not just as economists or public policy analysts, but in a sense as all three. So, you know, I'm very happy with the discussion. I found it very useful. And so then it just remains for me to say a few words of thanks. Firstly, to the Faculty of Law at the University of Ottawa, and particularly Tony Van Duzer. And secondly, to SSHRC, the Social Science and Humanities Research Council of Canada, which has been one of the sponsors of our workshop and also, therefore, of this panel. And then primarily, I think, to CIGI and to Una and her team, who've done an enormous amount of work in organizing the panel, in pulling the panel together, but also the audience. And I'm very happy to hear that they are continuing the interest in the topic later on this year. So with that, I want to thank Una and invite everybody for a drink outside.
In the investment area and advising governments, particularly developing country governments, on investment policy. And then finally, we have from the University of Calgary, Eugene Beaulieu, who is an economist and also teaches in the Faculty of Management there. So we have, I think, a very good panel, and with that, I think I will turn it over to Una. Thanks.
Thanks very much, Tony. Good evening, ladies and gentlemen. It's really a pleasure to be here, and the International Law Research Program of the Center for International Governance Innovation is very happy to be able to sponsor this event in collaboration with University of Ottawa and the World Trade Institute. So the theme is Canadian investment law and policy in the global context. Are we getting it right? And this is meant to be a complementary event to that workshop that was described by Tony a few minutes ago. Let me just tell you a little bit about the Center for International Governance Innovation and the International Law Program in particular. There is a little brochure outside you can get if you want more information, and you can certainly go visit our website if you're interested. We've been in operation now for 1 year, and our areas of research are international economic law, international environmental law, and international intellectual property law and innovation. So obviously the topic of investment, inward investment and outward policy on investment is very critical to our work. The research program is funded by co-funding from private donation by Jim Balsillie and also from the province of Ontario. And since we started our operations, we've already developed a number of research projects in these three areas of research. And the way we like to work is in collaboration with public, private, academic, and non-governmental.
All right, well, good evening, everyone. My name is Tony Van Duzer. I'm a professor at the University of Ottawa at the Faculty of Law. And on behalf of the faculty and our academic partner, the World Trade Institute, and our very generous sponsor, the Center for International Governance Innovation, CIGI, I'd like to welcome you to our panel tonight. The subject of the panel, as you know, is Canadian foreign investment law and policy in a global context. Are we getting it right? But before I turn matters over to our moderator, Una Fitzgerald, who, as some of you know, is the director of the International Law Research Program at CIGI, I did want to make a couple of comments about why it is we're having this event tonight. As some of you know, we're having at the University of Ottawa a workshop today and the next day where we have brought together experts in international investment from various disciplines, including law, economics, management, and political science, to talk about investment issues. And the goal of this workshop, there's essentially two goals of the workshop. The first is to get these people, assembled experts, to talk about a variety of subjects related to investment from their distinctive disciplinary points of view. And then through the comments and the discussion from the diverse group in the room, to try to see to what extent insights from a variety of disciplinary contexts and using a variety of different sort of approaches to this sort of global issue of international investment can actually help us to better understand how it is that countries can use laws, treaties, institutions, and other strategies to
Implementation of international trade and investment agreements. We'd also like to consider the evolution and development of these agreements and their impact on the global value change. And finally, we'll explore some of the criticisms, critiques, and the future prognosis for international trade and investment agreements. And so this will be quite a wide-ranging discussion. So with that, we will begin with our first question to the panelists. Developing Canadian investment law and policy requires addressing a wide range of issues, from domestic, economic, political, and constitutional considerations to international, regional, and bilateral relations and comparative advantages. So, in designing an inward investment strategy, what incentives and policy and legal frameworks tend to attract long-term investment? And has Canada got it right? Would we benefit from a more coherent national strategy, and could we do better in managing within our constitutional constraints? Should we start with Eugene?
Oh, sure. Okay, so I guess maybe to start with the last part of your question, can we do better? I think yes. So let's just start with that. Probably everyone can agree with that. In terms of, I guess, policies to attract FDI, does Canada have it right? Let me first start off by just saying that, FDI is so crucially important to our economy. I would argue to every economy, but if we're going to focus on Canada, FDI is what built this country and continues to build this country. And today we talked in this panel, in this roundtable about FDI, and around the table, people recognize the benefits of FDI. And one of the benefits, or I guess the key aspect of the benefit, is it typically involves
international law experts and stakeholders from Canada, from Ontario, and from around the world. So we're building many networks as we go forward. So let me just explain the format of this panel. We have two economists, esteemed economists, with a great deal of practical experience as well as academic experience. We also have two very experienced international lawyers, academics and practitioners as well. So I think we can have a lively debate about whether law policy leads and how it will change going forward. So as moderator, my task is really just to ask a few questions about different aspects of Canada's policy on inward and outward investment. And I hope that we will be able to have a good exchange among the panelists, and then there'll be time also for you to engage and pose questions. This is supposed to be a very interactive session. And when people start to flag, there will be refreshments outside, and we can continue the more informal discussion outside. So we have saved time on the introductions, so I think what we can do is let's just situate the panel quickly. You've already heard about the big project that Anthony Van Duzer and Stephen Gelb, who's sitting in the front row, are working on this topic. Today what we'd like to think about is, where are we? We find ourselves at a crossroads where there are many questions being raised about international investment agreements and investor-state dispute settlement processes. Today we'd like to explore the fundamental rationale for international trade and investment agreements. How do they create favorable circumstances? Do they create favorable circumstances? And how can we improve the negotiation and implement?
To improve their ability to attract foreign direct investment and to manage its effects, both to mitigate the risks and to maximize the likelihood that it will receive benefits. So those are papers that are being presented and commented on, and eventually those will be published in a book, we hope, around the end of this year. The second goal of the workshop is actually to talk a bit about a course that the World Trade Institute and the University of Ottawa Faculty of Law are planning to launch in 2016, which will take the sort of interdisciplinary learning that we hope will result from the workshop and use that as the foundation for the course material that we will deliver globally online beginning, as I say, in early 2016. So those are our two main goals. So in that context, we thought it would be useful to have a public session, both to advertise what we were doing a little bit, but also, and perhaps more importantly, to look at these issues in a Canadian context with a view to informing Canadian investment policy, looking at some of the challenges, looking at some of the options, and to do that by assembling a panel with a variety of points of view. And so I think we can anticipate from that standpoint a lively discussion from the panel that we've assembled. So with that general introduction, I'll just introduce briefly the members of the panel. Starting on my extreme left, your right, we have John Weeks, who is a longtime Canadian public servant and former Canadian ambassador to the WTO, and currently a senior business and policy advisor to the firm of Bennett Jones on issues related to business, government relations, and international trade. Beside him is David Schneiderman, who is a well-known expert in international investment law and teaches at the University of Toronto. Beside him is Howard Mann, who is the senior advisor on international law for the International Institute for Sustainable Development. And Howard has years and years of experience working in